Hi everyone, it's Aisha Chidole from the Chidole Law Firm. I'm an immigration attorney here in Orlando, Florida area, but I represent clients nationwide and all over the world with your family immigration matter. If you would like assistance, give me a call. My number is 407-995-6567. So today I want to talk about what is the difference between a 2-year green card and a 10-year green card. Basically, another word that we use for a 2-year green card is a conditional green card. And a 10-year green card is simply that your 10-year legal permanent residence. So it is permanent. Well, unless you commit a crime or something that causes your green card to be revoked. Basically, if you've been married for under 2 years, when you do get your green card, you will get a 10-year green card. If you've been married for over 2 years, when you get approved for your permanent residency, you will get a 10-year green card. With a 10-year green card, you can remove or you can file for citizenship, after 3 years if you're still married, or after 5 years if you're no longer married. With a 2-year green card, you cannot file for citizenship until you remove the conditions on your green card or I should say you cannot be approved for citizenship until the conditions in your green card have been removed. How do you remove the conditions in your green card? Essentially the same steps as when you file for your application for a green card with your spouse or whatever. You want to be able to show that you are still in a bona fide good faith marriage. So a lot of the evidence are going to be the same, but you want to provide new evidence from the 2 years while you guys have been together. Sometimes marriages don't work. Understandable. If your marriage didn't work out and you filed for divorce, you can still file for a removal of the condition, but you're going to require a waiver to do that. You need a waiver to say, please exempt us from filing with, or exempt me from filing with my spouse because there was a divorce. But you want to be able to show that even though you're asking for that exemption, that you did have a good faith marriage. It's just that it didn't work out. Another way to remove the conditions without your spouse is if you have an abusive spouse or a spouse that's extremely cruel, or you have crazy marital problems where you know that your spouse is not on board with you, your spouse stresses you, or your spouse causes you anxiety and depression. Same thing in that case, you can request for a removal with a waiver not to file with your spouse. We just have to be able to provide very strong testimony of what happened in your marriage and why it didn't work out. And the other way which you can remove, this way, I always try to see if you can do it one or the other ways. But another option is if you can show extreme hardship. Extreme hardship is that if they don't remove the conditions, it will be extremely hard, for you, and it has to be really significant. So, but it's a very hard one to sell. So, with waivers, usually the best options, if available, it's based on divorce or based on extreme cruelty in your marriage, but you always want to still show that you did have a bona fide marriage. I hope you found this video helpful. My name again is Aisha Chidole. I can help you with your conditional removal. My number here is 407-995-6567. Have a great day. Bye.